At this stage, we want to hear from the author. I think that's one of the most exciting things when you read a book. What was in the author's mind? So we want to hear the story behind the book, pretty much inside the chapters. So this is a very special section that I think we also need to celebrate the man who has made it possible. But a bit about the man we're celebrating today. He's a Zimbabwean legal scholar, author, and a registered legal practitioner whose work spans constitutional law, land reform, succession, property law, human rights, with a sustained focus on historical justice and reparations in post-colonial Africa. He practices at Shonai Law Chambers in Harare as a legal practitioner, conveyancer, notary public, Commissioner of Oaths. Okay, but it's fine. And a Commissioner of Oaths, combining litigation, commercial advisory work, and conveyancing with ongoing academic inquiry into law, equity, sovereignty, and restorative justice. He holds a Bachelor of Substantive Law and a Bachelor of Procedural Law, BLS, BLP, from the University of Zimbabwe, a Certificate of Intellectual Property from the World Intellectual Property Organization. He has a very, very long profile. I won't be able to finish reading everything. But gentlemen, at this stage, I'm going to ask you, why don't we give this man a standing ovation as we give him a round of applause as he's coming through. Inside the chapters, we celebrate Mr. STANDA Sani tonight. We can do better than that. I'm not sure if you're ready. Are you connecting something? Okay, it's fine. So just says a minute again, just have a seat. But let's take our seats. He's also looking very, very smart, eh? Yeah. So I think he's now ready. All right, perfect.
Program Director, Honourable Judges here present, distinguished guests, members of academia, colleagues from the legal profession. I understand we also have students of law. Ladies and gentlemen, good evening. It is a privilege and a humbling experience to stand before you today at the launch of Land, Law and Legacy, Zimbabwe's quest for justice and reparations. I am deeply honored by your presence and grateful to everyone who has taken the time to share this important occasion with me. Before I speak about the book itself, I wish to express my sincere appreciation to the many people and institutions that made this work possible. I thank the University of Zimbabwe Press for believing in the manuscript. It actually took a horrendous 3-year period, but it was quite enjoyable. I would like also to thank Shonai Law Chambers, Mr. Kenneth Shonai here present, who has given me a platform to excel. So tonight, ladies and gentlemen, I've been asked to speak on particularly 2 things. Number 1, the story behind the book, and also the outline of its chapters. The story behind the book. Every book has a story before it becomes a manuscript. The story behind this book began long before I sat down to write a single chapter. It began with a question that has troubled Zimbabwe for generations. Can the land question in Zimbabwe ever be understood properly without first understanding injustice that created it? That is the fundamental question that should be at the heart of every Zimbabwean. For many years, ladies and gentlemen, discussions about Zimbabwe's land reform have been dominated by politics, economics, and international commentary. Yet, I often felt that something fundamental was missing from those discussions. We frequently debate what happened in 2000, but we rarely examine with equal intensity, ladies and gentlemen, distinguished guests, what happened in 1980. But why don't we take it back to 1890? We flip the digits a little bit. 1980, we flip the digits to make it 1890 when all it began. In 1918, when the Privy Council, Lord Sumner, ruled that an indigene of African origin had no sense of property. Therefore, he could not take part in that space. As a legal practitioner and scholar, I became increasingly interested in the legal architecture that facilitated dispossession. I wanted to understand not only how land was taken, but how the law was used to legitimize its taking. The more I researched, the more I realized that Zimbabwe's land question is not simply about agriculture, productivity, ownership, or compensation. It is fundamentally a question of justice. How do we respond, therefore, when an entire people are dispossessed of their ancestral lands? How do we reconcile competing claims that arise after more than a century of colonial occupation and domination, subjugation, and decades of post-colonial reform? How do we balance property rights, sovereignty, historical truth, reconciliation, and human dignity? These questions led me into history, jurisprudence, constitutional law, international law, political philosophy, and comparative studies. Ladies and gentlemen, what began as a legal inquiry eventually became an exploration of a broader moral question. What does justice require when a nation seeks to correct historical injustice? This book, therefore, does not seek to celebrate or condemn any particular political actor. Rather, it seeks to understand. It seeks to explain. It seeks to provide context. And above all, ladies and gentlemen, it seeks to contribute to a more informed national conversation. One of the central arguments of this book is that land reform should not be viewed merely as a policy choice. It must also understand as part of a larger quest for historical justice and national restoration. The book also advances an argument, ladies and gentlemen, that is sometimes uncomfortable but necessary. That Britain bears a continuing moral and historical responsibility for the colonial structures that produced land dispossession and should engage in meaningful dialogue concerning reparative justice. Ladies and gentlemen, whether one agrees or disagrees with that proposition, I believe it really deserves serious scholarly consideration. And this is why I decided to take part in that context. This book is therefore an invitation, ladies and gentlemen, not to division, but to dialogue. It is an invitation not to division, but to dialogue. Not to hostility, but to understanding. Not to revenge, but to justice. Now, the outline of the chapters. Part 1, I covered historical context and legacy. The first part of the book seeks a simple question. The chapter invites readers to reflect on a difficult truth. Constitutionalism does not always guarantee justice. In chapter 4, the Aristotelian concept of justice and land dispossession. This is perhaps the philosophical heart of the book. Here I move from history and ask, what is justice? Drawing on Aristotle's concept of distributive and corrective justice, I examine whether land reform can be understood as an exercise in restorative justice. The chapter also engages broader theories of justice and racism. Its purpose is to provide a moral framework through which the land question can be analyzed. In chapter 5, there is the deliberate continental integration against colonialism and neocolonialism. This chapter places Zimbabwe's struggle within broader African context. It examines Pan-Africanism, the role of Organization of African Unity and later the African Union, and the collective efforts of African states to dismantle colonial rule. I also discuss reparations movements and compare African claims for historical justice with other international experiences, including discussions arising from the Holocaust. The Holocaust, ladies and gentlemen, was a very disturbing event that took place, and over 6 million Jews were massacred. But in Africa, close by, in the Congo Basin, approximately over 13 million people under the rulership of King Leopold II were also massacred. But very little is spoken about that. For that reason, ladies and gentlemen, I had skipped to chapter 4. I will now take you back to chapter 2, which speaks of a labyrinth of laws, disposition, and the Privy Council judgment. This chapter explores what I call the legal architecture of colonial disposition. It was a very coordinated effort. They met in November of 1884 until February thereabout of 1885 to subdivide Africa. I have often said it in a number of fora that what we do have in Zimbabwe as we speak, we do have chiefdoms. But celebrated as that may be, the chiefs that we have were not supposed to be in the areas that they are as we speak today. Their areas are the areas in which they were dispossessed from through the colonial statutes, the likes of the Land Apportionment Act of 1930, and so forth and so on. And it was a concerted effort of 90 years to make sure that the black indigene was dispossessed, and the law actually protected that. Ladies and gentlemen, let me hasten to also indicate that what we inherited at independence, as most people would want to call it, was not necessarily the rule of law. It was, in my respective view, rule by law, because we then inherited that legal architecture, which we then carried into the new birth of Zimbabwe. Chapter 3, ladies and gentlemen, speaks about the Royal Charter and 5 constitutions of Rhodesia. In this chapter, I examined the constitutional foundations of colonial rule. The chapter follows constitutional developments from the Royal Charter granted to the British South Africa Company through successive constitutions of Rhodesia. I demonstrate, ladies and gentlemen, how constitutional instruments were repeatedly used to preserve racial privilege and unequal access to land. It is this backdrop, ladies and gentlemen, that we took over post-independence. I want to believe our leaders back then believed in the concept of inching, that as much as we may have gained a traction, one step at a time, let us gather sovereignty and then use the law perhaps. I like what Professor Maduku then puts it in constitutional law studies, that it was actually what he called the Mugabe jurisprudential approach. The land would be taken one way or the other, skirmishes would take place, the court would sit to determine, and the judges will be limited to what the law says in interpreting what it ought to mean, giving respect to the framers of the statute, the legislative intent. Now, if a judgment would come that is contrary to the development and the equitable distribution of land, the Mugabe jurisprudential approach would then allow the course of justice to take its course, but then entrench to use the majority rule in parliament to effect new laws that would then transform what then the judges would interpret in court. Ladies and gentlemen, I will now skip to part 2 of the book that speaks of legal frameworks, independence, and compensation puzzle. Having established the history, I then turn to the law. Chapter 7, International Legal Frameworks and the Right to Restitution. This chapter, ladies and gentlemen, explores international law. It analyzes instruments such as the Universal Declaration of Human Rights and the United Nations Declaration on the Rights of Indigenous Peoples. The chapter asks whether international law provides a framework for addressing historical dispossession and facilitating restitution. Chapter 8, ladies and gentlemen, It speaks of the final stages of colonialism in Rhodesia. This chapter examines the transition from colonial rule to independence. I analyze the Lancaster House negotiations and the constitutional compromises that emerged from them. Particular attention is given to the property clauses that would later become central to debates over land acquisition and compensation. Chapter 9, ladies and gentlemen, speaks of land rights in independent Zimbabwe. This chapter follows Zimbabwe's land reform journey after 1980. I examine the first phase of land reform, constitutional amendments, and successive legislative measures aimed at addressing inherited inequalities. The chapter demonstrates that land reform was not a single event, but a gradual process spanning decades. Chapter 10, ladies and gentlemen, it speaks of the fast-track land reform program. This chapter compares Zimbabwe's experiences with South Africa, Namibia, Eswatini, and Australia. The purpose is to identify lessons, similarities, and differences that may inform future policy. Part 3 of the book, ladies and gentlemen, speaks of justice, reconciliation, and the path forward. This final section asks not where we have come from, but where we are going. Chapter 14, the impact of the fast-track land reform program. In this chapter, I examined the consequences of land reform on displaced white commercial farmers and their communities. The discussion includes economic, social, psychological, and legal dimensions. Justice requires intellectual honesty. It requires us to acknowledge human suffering wherever it occurs. Chapter 15, ladies and gentlemen, addresses historical injustices. This chapter explores models of reparations. I discuss restitution, financial compensation, symbolic recognition, development investments, and other restorative mechanisms. The chapter argues that meaningful reconciliation requires more than just political rhetoric. It requires tangible measures aimed at restoring dignity and addressing historical harm. Chapter 16, ladies and gentlemen, that speaks to the heart of the book in my view. It talks about Britain's obligation, addressing collective harm and responsibility. The final chapter addresses what many regard as the most sensitive issue in the land debate. I argue that Britain's role in creating the colonial system imposes a continuing moral, legal, and historical responsibility to participate in conversations concerning reparative justice. This chapter, ladies and gentlemen, is not about assigning perpetual guilt. It is about recognizing historical responsibility and exploring pathways toward healing, partnership, and reconciliation. In my closing remarks, ladies and gentlemen, if there is one message I would like readers to take from this book, it is this: the land question in Zimbabwe cannot be reduced to a dispute over property. It is more than that. It is a question of history, law, identity, memory, justice, and national healing. This book does not claim to have all the answers, ladies and gentlemen. Rather, it seeks to ask the right questions. It invites us to move beyond the simplistic narratives and engage honestly with one of the most important issues in Zimbabwe's history. Ultimately, land, law, and legacy. Zimbabwe's quest for justice and reparations is not merely simply about the past, it is about the future we wish to build, one founded on truth, justice, reconciliation, and dignity for all Zimbabweans. Ladies and gentlemen, thank you.